This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. You may have heard that Zoom is in some hot water for some of its privacy concerns and faults in its software. There's several, actually. There's one where they were using the Facebook login, and Zoom may or may not have known that the Facebook login SDK, software development kit, so the software library that allows that to work, apparently says it sends a bunch of private information back to Facebook. So if you use Zoom, I'm not sure if it might even do so even if you're not using the Facebook login yourself. So if you don't click login with Facebook, I think it still does it, where it sends private information back to Facebook. So that's one of them. Another one has to do with the way it handles links. If someone uses a UNC path to link to something, they can apparently insert some malicious code in there and get access to your username and password, potentially under the right circumstances. There are some other concerns about the vulnerabilities in Zoom that they're working on patching. There was a whole write-up. I'll see if I can put a link in the description from a computer professional. So there has been now a class action lawsuit filed about that. And so this is Robert Cullen versus Zoom Video Communications trying to bring a class action lawsuit. Zoom provides an overwhelmingly popular online video conferencing platform, which involves all this stuff. Zoom's stock price has skyrocketed up over 115% in the last 2 months. However, they failed to properly safeguard the personal information of the millions of users of its software application, the Zoom app and video conferencing platform. Upon installing or opening the Zoom app, Zoom collects personal information of its users and discloses, without adequate notice or authorization, this personal information to third parties, including Facebook, invading the privacy of millions of users. By this action, plaintiff and members of the class seek damages and equitable relief, which is an injunction, to remedy defendants' violations of California's unfair competition law, the Consumer Legal Remedies Act, and the Consumer Privacy Act. We'll skip jurisdiction. We'll skip the parties. Zoom provides video communication products. Zoom users can host or participate in video conferences through several means. There are apps and web browser methods to access conferences. Zoom may be identified as Zoom Cloud Meetings on the iOS store. Zoom boasts its appreciation for the importance of maintaining users' privacy, saying, "You trust us to connect you to the people that matter. We value that trust more than anything else. We want you to know what data we collect and how we use it to provide our service." Zoom's privacy policy purports to identify and disclose to its users all the information Zoom automatically collects from its users when they interact with the products. However, defendants' statements regarding the inviolability of its users' privacy and personal information are false because defendants' wholly inadequate program design and security measures have resulted in unauthorized disclosure of its users' personal information to third parties, including Facebook. Its privacy policy represents that it utilizes a combination of industry standard security technologies, procedures, and organizational measures to help protect your personal data from unauthorized access, use, or disclosure. Zoom, however, included in the app, without any adequate disclosure to users, code that made undisclosed disclosures of users' personal information to Facebook and possibly other third parties. I think this might have been hastily written. Can you tell? Okay, so Joseph Cox, March 26th, posted a report on Motherboard for Vice Media Group documenting the behavior of Zoom app's unauthorized disclosure of users' personal information to Facebook. The report states that the Zoom app notifies Facebook when the user opens the app details on the user's device, such as the model, time zone, and city, so some kind of location data, which phone carrier they are using, and a unique advertiser identifier created by the user's device, which companies can use to target a user with advertisements. So even if you didn't log in, it looks like, it doesn't say anything about having to log in here at least. that it appears that you get a unique identifier assigned to your device from, like, your device creates it so that when you access Facebook at a later time, or a site that also uses the Facebook SDK, they then know who you are. Even if they don't know specifically what your name is, they might know this is the same device that used Zoom a little while ago, and they can advertise to you things that they think would be useful to Zoom users. Maybe, I don't know, webcams and other services or something. Plus, they can then track you as you go around the web and load up web pages if you don't have a script blocker or a tracking cookie or tracking identifier blocker like uBlock Origin or something. And even then, I'm not even sure how effective that is. I have not technically looked into it. As stated in the motherboard report, the findings by Mr. Cox were verified by an iOS researcher, Will Strafosh. He's a researcher and founder of the privacy-focused iOS app Guardian. The unauthorized information is sent to Facebook when a user installs, and each time a user opens the Zoom app, so it doesn't look like you have to log in. This information includes users' mobile OS, type and version, device time zone, device model, unique identifier. The amount of money Zoom receives from Facebook is unknown by plaintiff. So are they getting paid by Facebook to do that? I don't know. I don't think so, but they could be. Had Zoom informed its users that it would use inadequate security measures and permit unauthorized third-party tracking, plaintiff and others would not have been willing to use the app. Instead, plaintiff and class members would have foregone using Zoom and chosen a different video conferencing product. Zoom's failure to provide adequate disclosures and security protocols violated users' privacy. Then they admitted publicly on their website that it was sending at least some information to Facebook upon installation and opening and closing of the Zoom app. Application bundle identifier, application instance ID, application version, device carrier, iOS advertiser ID, device CPU cores, disk space available, disk space remaining. Not sure what the difference is there. I guess available would be the total amount. Display dimensions, device model, language, time zone, version, and IP address. And we know that IP addresses can be used for basic geolocation, so they can at least pinpoint you to a region of the world, down to about the county level is my understanding of it. Even if it, I often rail against companies like Strike 3 Holdings that use that for suing someone, and I don't agree with that. But I definitely agree that IP addresses can be used to geolocate somebody to at least a county or maybe surrounding county level. So within 30 to 50 miles, it sounds like they could at least get some kind of guess as to where a person is located. Now that can be messed with, but how many people actually do that? Very few. Zoom further admitted that these unauthorized disclosures for which no adequate notice was provided, doubling down there, were implemented by a login with Facebook feature using Facebook's software development kit. So now, pardon me for a moment while I defend Zoom. I could have made this same mistake. Any of us could have made this same mistake just by implementing the login with Facebook feature. What's really happening here is Facebook is really broad with its information grabbing. If you use the Facebook SDK, you probably ended up disclosing this information too. So be very careful when you implement that login with Google or login with Facebook or login with somebody else's service or something. When you're using their library, you have to be aware of what their library has access to. If you have just included their library in your code and didn't otherwise look into how to disable these features and weren't able to disable these features because they might be required or something, then you have to disclose this as well. Now, Zoom probably could get away with this if they had simply disclosed it up front. And it sounds like they forgot. In their defense, it sounds like this was more of a negligence act than an intentional act of trying to misinform users. But I'm not saying it is, but it just sounds like it. It feels like it at this point. So Zoom fixed these problems by releasing a new version of the app, which no longer sent unauthorized personal information. However, even assuming the updated version works as described, the harm done to the plaintiff and class members continues. Zoom has taken no action to block any of the prior versions from operating. Thus, unless users affirmatively update their app, they likely will continue to unknowingly send unauthorized personal information. Zoom has not taken actions to compensate its users for its failure to properly safeguard their personal information. So they make class allegations. They have to name a class. Their class is all persons and businesses in the United States whose personal or private information was collected and disclosed by Zoom to a third party upon installation or opening of the Zoom video conferencing application. They exclude certain people from the class, like officers, directors, employees of the defendant, etc., people who aren't allowed to be part of that class. They have to define this properly, or else the court will decline to allow a class action. Common questions of law or fact. Yep, so in order to have a class action, you have to have common questions of law or fact. Whether defendant failed to adequately safeguard the class member's property, including their personal information, whether they engaged in unfair or deceptive practices, whether they violated consumer protection statutes, whether they acted negligently. I think they at least acted negligently. Or whether they collected personal information of the plaintiff and provided it to third parties without providing a required notice, and whether the plaintiffs are entitled to injunctive relief and damages. So they continue to talk about all the things they need to do for a class action, and then they get into the claims for relief. They're talking about violations of the California Consumer Privacy Act, which went into effect this year, apparently. They violated the California Consumer Protection Act or Privacy Act by collecting and using personal data without disclosure. Defendant knew or should have known, so there's the standard for negligence, knew or should have known. And that's the only really interesting thing there. Unlawful and unfair business practices. We've seen this California code before, 17,200 et sequitur. They're saying that they engaged in unlawful activity prohibited by the UCL, which is unlawful, unfair, or fraudulent business act or practices, and unfair, deceptive, untrue, misleading advertising. So by not disclosing to you what they were disclosing to Facebook, they unfairly competed. They gained a market advantage. You thought that you were safe. If you thought that you were not safe, you might use a different competing product. Now, I'm assuming Skype doesn't have these problems. Now, what's the difference? Skype might be doing the exact same thing. I don't think it is, because I don't think it has a login with Facebook button. But Skype might be doing the exact same thing as long as they disclose it to you in the privacy policy, which is properly noticed to you. If you go read Skype's privacy policy and it says we use login by Facebook and it discloses all these things, then yeah, that's not a violation because they told you. Businesses that collect consumers' personal information shall, at or before the point of collection, inform consumers as to the categories of personal information to be collected. That's the CCPA. And so they go into what personal information is, and we all pretty much agree what personal information is. Consumers Legal Remedies Act from California, the CLRA, Consumers Legal Remedies Act, is a comprehensive statutory scheme prohibiting various deceptive practices in connection with the conduct of a business providing goods, property, or services to consumers, primarily for personal, family, or household purposes. The self-declared purposes of the CLRA are to protect consumers against unfair and deceptive practices. So same thing, it's an unfair competition thing because they have an advantage over others similarly situated, and it is a deceptive practice because you didn't disclose to the consumers what you're supposed to disclose. Negligence, there it is. I thought that they would put negligence in here. Negligence is a very basic tort. It's a civil wrongdoing, and it basically says that they had a duty to you, in this case to protect your private information that they had not told you was going to be disclosed, that they breached that duty, that it caused you an injury, and that injury resulted in damages. Duty, breach, injury, and causation, and that they were the direct but for factual cause and the legal cause of the injury. So the legal cause is called proximate cause, and that's the idea that if there's too many steps in between, even if the original thing caused the dominoes to start, there's a number of dominoes in between that remove liability legally from someone. The example, of course, is the Ms. Palsgraf case, Palsgraf versus Long Island Railroad, which was a very, very famous New York case that we use as the example for explaining proximate cause. And so Ms. Palsgraf was on the train platform. The train conductor was helping a man with a box of fireworks or explosives get onto the train. The box fell. The explosion caused a chaos, and in the chaos, a piece of equipment, a weighing scale, a measuring scale for measuring the weight of cargo, fell on and injured Ms. Palsgraf. And so could she sue the guy with the fireworks? Probably, but she didn't. She sued the Long Island Railroad. Is the railroad legally responsible for her injuries? And the answer was no. Proximate cause intervened. Even though the conductor trying to help the guy with the box might have been the factual cause, the but-for cause, Ms. Palsgraf would not have been injured but for the Long Island Railroad conductor trying to help the guy onto the train. That's fine, but that's not the end of the inquiry. So yes, that's the but-for cause, but is the guy getting on the train with a box that the conductor doesn't know contains fireworks, can the Long Island Railroad and the conductor reasonably foresee that helping a passenger on with a box is going to cause an explosion, that's going to cause a panic, that's going to cause a scale or piece of equipment to fall, that's going to cause Miss Palsgraf's injuries? That's too far removed. And so that's what we call proximate cause. So duty, breach, injury, and causation. And so that's the accusation here, is they had a duty to safeguard your data. They breached the duty by failing to implement and maintain reasonable security protections and protocols. They knowingly disclosed users' information, etc. That there was damage or injury to the class members. And there we go, proximate, reasonably foreseeable result of the breaches. So that they're going straight after proximate cause because they know that that's going to be one of the defenses. Invasion of privacy is another one. Class members have a legally protected privacy interest according to California law, and by disclosing their information unauthorized because it wasn't in your privacy policy, then you have violated those consumers' privacy rights. Unjust enrichment. Oh, I love it. I love it. So unjust enrichment is when you receive a benefit to which you are not entitled. So in this case, the market advantage, I'm going to guess, is what they're going after here. As a direct and proximate result of the unlawful conduct, defendant has been unjustly enriched. Defendant's unlawful acts, including the unauthorized transfer of personal data, they have benefited from their unlawful acts, and it would be inequitable or untenable for defendant to be permitted to retain the ill-gotten gains. The defendants or the plaintiffs are entitled to an amount of defendant's ill-gotten gains resulting from its unlawful, unjust, and inequitable conduct. And that's it. And then they pray for relief. They want a court to declare that these are all violations, enjoin them, which is where the injunction comes into it, enjoin them from continuing the illegal activities, pay interest, and all other relief. They want a jury trial. I can understand that because a jury would probably side against Zoom and in favor of the class. So if you've been injured by Zoom, which I think I have as well. I think I logged into a Zoom conference a week or two ago, so I guess I'm part of this class. So if you want to be part of this class, I think all you have to do is follow this lawsuit and do nothing and wait for your notice of class membership in the mail. If you don't want to be part of the class, then you have to wait for that and then opt out, I believe is the way that's going to work. Also, this might only be for California. Let me do a quick look here because they cited a bunch of California laws that aren't going to apply outside of California, right? This says all persons in the United States. So I think that includes everybody, and they're just using California unfair competition law to get there. But so Yes, all I have to do is nothing. That is my favorite degree of effort, says Goliath Cleric. Thank you very much. I agree. I agree. What do you think of that? Let us know in the comments below, and we'll follow. I'm going to attack, if you could make sure we track that lawsuit, because I really want to see what happens next with that. Because this is a class action, so they can't just settle with the plaintiff. They have to settle with the whole class. So it's all persons in the U.S. whose personal or private information was collected and disclosed by Zoom to a third party upon installation or opening of the Zoom video conferencing app. So yeah, if you've used Zoom, you are technically part of this class. If you used it before they made the changes, or you used a version of the app that didn't have the changes that removed the private data collection. That's how simple it is to make a privacy violation. Just implement a Facebook library. That's how vulnerable we are to, like, so when you use the so maybe a developer can tell me, when you use the Facebook SDK, does it also come along with a privacy notice that says, by the way, make sure you inform your users of these privacy problems? No, I don't think it does. And isn't that another shady act by Facebook? Does anybody have any doubts in their mind as to why some people, me, don't like using Facebook? It's because they collect too much information. They don't inform people of the consequences. So they didn't inform Zoom, in my opinion. This is just my opinion, an allegation. I don't know if this is true or not, but it sounds like they didn't inform Zoom. By the way, when you use login with Facebook, make sure that you know to inform your users that we're tracking all this information, that we're pulling all this information from their devices. And it sounds like Zoom didn't know, even though they should have known because they implemented the SDK. Now, does that mean that Facebook gets sued? I don't think so, because I'm guessing that Facebook knows all of this and Facebook disclosed all of this in like some privacy notice. I just mean that, like, if I wrote a software application that did this, I would feel at least some moral obligation to make sure that my users knew, by the way, when you use my software library, here's what you also need to know legally. Maybe that's just me. Let us know what you think in the comments below. So thank you for watching. I hope you enjoyed that. I'm Leonard French, your favorite copyright attorney. Please leave your comments in the comments below. Please like and subscribe if you like what I do. Please hit the dislike button if you dislike what I do. That also helps the channel. If you really did dislike it, that at least shows user engagement. So thank you to those of you who support our channel financially on patreon.com/ljfrench and sponsors.com/law. This channel would not exist without your financial support. Thank you to our $50 plus supporters in the month of April: Wes Delj, Video Quarantined, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Michael Pearce, Jan Negrey, Daniel Perez, Aspernari, Joe Tyson, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Nicely Done Defense, Wesley Mullen, Mullen PC, Sean McNamara, Josh Baker, Ugly Grill, Gregory, Shielo T, Michael Moore, and Beastman. And the $5 plus supporters are on the LED panel next to me here, and will be scrolling on the screen in front of me, and you're all in the description of the videos that drop. I'll let you go. I love you all. Have a great one. Stay safe, stay healthy, wash your hands, shelter in place, wear your masks if that's what the CDC and the Surgeon General and the WHO are now saying, and just stay safe and healthy, everybody. We'll get through this together. Love you all. Bye.